Mr. Chief Justice, and may it please the court, my name is Eternal Morris, and along with my co-counsel, Brittany Stankavage, we represent the respondent, the state of Olympus. The respondent respectfully requests that this court affirm the decision of the trial court because Mr. Bronner's Fourth Amendment rights were not violated by the police obtaining his cell phone records. There was no search, and if this court were to rule a search did exist, the exigency exception applies to make the warrantless search reasonable. Your Honors, in Katz v. United States, the court rules that a search happens anytime a government official intrudes upon a person's actual expectation of privacy, and this expectation of privacy is one that society is willing to recognize as reasonable. The petitioner in our case neither had an actual expectation of privacy nor a subjective expectation of privacy in his cell phone records. The petitioner states that this case has similarities to Carpenter v. United States. However, Carpenter leaves over for discussion whether surveying someone's cell site location information in real time constitutes a search. Contrary to what the petitioner has stated, Carpenter does not answer whether the obtainment of someone's cell site location information in real time constitutes a search. This question was left unopened by the court because the court understands that there are different factors to consider for real time data. As the petitioner has demonstrated, Carpenter is the extreme case because the police in that case achieved near perfect surveillance, collecting over 100 data points each day over the course of 127 days. The only limit to their search was the cell phones company retention policy. In the case before us, page 4 of the record states that the officers were notified in real time anytime Bronner's cell phone was within 5 miles of 10 specific location, and every phone number that Bronner communicated with when his phone was within 10 miles of these same 10 specific addresses over the course of 8 days. The search in this case was narrowly tailored to 10 public places of interest. The utility of this information could only tell officers where Bronner may be and could not reveal in specific terms any intimate details of Bronner's life. Moreover, the petitioner argues that because a person is unknowingly giving his or her information away to a third party, he or she maintains a reasonable expectation of privacy in the information. However, it is likely that a cell phone user knows that he or she must allow his or her cell phone company to track his or her device for business purposes. This is the sometimes unspoken agreement between the cell phone provider and the end user. A cell phone user acquiesces to a business company recording his or her information for the company to provide service to him or her. This cannot be argued to be unknowingly or without the consent of the end user. A cell phone user agrees to give up certain privacy rights to be able to use his or her cell phone. The ruling in United States v. Miller is unequivocal. Anytime a person willingly gives up his or her information to a third party for a business purpose, he or she can no longer claim a legitimate expectation of privacy in that information. The petitioner also cites United States v. Jones to say that a person has a legitimate expectation of privacy in his CSLI data. While this may be true, this does not discount from the fact that when a person willingly gives up his or her information to a third party, he or she is no longer the sole owner and thus no longer the sole arbiter of how that information is used. Also, the petitioner states that because there's a great deal of information encoded on a cell phone user automatically maintains his or her legitimate expectation of privacy in his cell phone. This argument would be applicable if the officers in our case searched the data on a cell phone. They did not. They merely obtained records from the cell provider anytime cell phone provider to show where Bronner's phone communicated with the cell tower within 5 or 10 miles of 10 specific addresses. The petitioner was correct to state that the government believes that Riley v. California is inapplicable to this case because it was held in a different context. The officers in Riley already had the phone in their possessions after they had made a lawful arrest. The officers decided to search the content of the phone, as the petitioner correctly mentioned. The petitioner agrees that there is a difference between our case and Riley. However, the petitioner conflates the two contexts under the same doctrine. This is an error. The police in Riley searched the digital data of a person's cell phone. In our case, officers could not search the digital data of Mr. Bronner's cell phone because they did not possess his cell phone. Thus, they could not intrude on Bronner's expectation of privacy in the digital data on his cell phone. This makes all the difference. Moreover, the petitioner draws parallels between Kyllo v. United States and our case. The court held that the police conducted a search in Kyllo. The court held that a police conducted a search of Kyllo's home because they used technology that was not within general public use to ascertain information that they would not have been able to ascertain without being physically present at the place to be searched. The petitioner, however, does not mention that the basis of the court's decision in this case was because the officers searched inside Kyllo's home. Any search inside a home is presumptively unreasonable. In the case at bar, the officers did not search inside Mr. Bronner's home. In fact, they did not even search inside the public places of interest. The officers in our case could not know where Bronner was at any specific time, and they were incapable of knowing what was going on within those 10 specific places. Also, because the public possesses tracking technology to track a person's cell phone, the petitioner argument also fails. What is not in public use is a heat detecting device that is capable of searching inside a person's home. To my second point, Your Honors, the petitioner states that there are no circumstances, exigent or otherwise, to dispense with the warrant requirement. However, as the petitioner correctly states, in Missouri v. McNeely, the court says that a determination of the exigency should be based on the totality of the circumstances. This case presents all elements of exigent circumstances that the Kentucky v. King court discusses, such as preventing the destruction of evidence related to the crime, and not just Bronner's cell site location information, was in jeopardy of disappearing with the North operation moving to Las Vegas, pursuing a fleeing suspect. Because of the suspects in this case were leaving Olympus to go to Las Vegas, they were by definition fleeing suspects. And to render emergency aid, page 2, footnote 2 states that at any time 2.4 million people are caught in human trafficking situation. This means that human trafficking is a problem for the community and individuals, and it is likely to assume that at any time there is always a need to render emergency aid to a human trafficking victim. Coupled these circumstances with the severity of the crime, the connection that the police officers in this case made, the connection that Mr. Bronner had to one of the most egregious human traffickers in western United States. Page 2 states that the officers in this investigation were the leaders of the investigation of the North, and the law enforcement running low on time to prove criminal action and apprehend suspects. The need of law enforcement was so compelling to dispense with a warrant requirement. Also, Kentucky v. King states that the police are not required to a criminal investigation at the earliest time probable cause arises. For the reasons stated above, the respondent respectfully requests that this court affirm the decision of the lower court. Thank you.